Welcome and good morning, everybody, to Fact Friday. This week, Mary and I will be looking at the different type of will structures you can include, and in particular, the basic will. Most people think their proposed ideas or circumstances are fairly basic. In fact, they probably are. However, in certain circumstances, having a more complex will may indeed offer more protection. Previously on Fact Fridays, we have looked at executors, and executors would have to be a part of any will that you prepare. Other items in a basic will include revocation of all previous wills you have prepared, personal possessions, and possibly a guardianship clause for minor children you have under the age of 18. A good example of a basic will would be a single person leaving their assets to a named individual or even a group of individuals in equal shares. Another example would be for a married couple to leave everything outright to one another and then to children on the second death. Mary, we have 3 questions today we need to answer. The first question is, a client of mine is sadly a widow and wants to leave everything to her children, but not her grandchildren. How can this be achieved?
So it can be, but in broad terms, the law would say that if you leave a gift in the will to your child and then that child dies before you, if the child leaves issue of their own, that's children, grandchildren, etc., they would automatically become entitled to that share of the estate unless a contrary intention appears in the will. So if it's intended that if one of the children dies, their own children should not inherit that share, then you would need to make sure that's expressly excluded from the will from happening, and that would be excluding Section 33 of the Wills Act 1837, which the lawyer would be able to deal with in the will.
Excellent, thank you. And the second question, what happens if I have more children or even grandchildren at a later date after already preparing my will?
So it depends how the will was drafted. So when making a will, it isn't necessary to specifically name the people whom you'd like to inherit your estate, and it can be drafted in such a way that it makes provision for any future children or grandchildren who may survive you. So if someone's already made a will, it would need to be reviewed. If it doesn't provide that flexibility for future children and grandchildren, then a new will would be best to be prepared for them.
Excellent. And the third and final question, Mary, is a husband and wife want to leave everything to each other. However, they are worried about future care fees. How can this be achieved?
So they can get some advice on this. As you mentioned, today was about basic will structures, so that would not be included. It would need to be some form of a trust included within the will, and that could be discussed with the lawyer preparing it. And I believe you're going to be covering this in a later Fact Friday.
I will be indeed. However, next week I will be joined by the amazing Alexandra Gordon, and we will be discussing provisions for children within your will and the different types of trusts and provisions you can include. Mary, thank you so much, and I hope to all see you next week. Take care.